There is a phrase floating around in old legal language that sounds powerful. When you are representing yourself, not learned in the law, if you are pro se, that phrase may feel like a shield. In fact, it has a legal definition, and you may be surprised to learn it. Also refers to those with legal degrees who have been disbarred, or have simply never passed the bar. You may think, I am not a lawyer. I did not go to law school. I do not know the same rules attorneys know, so the court cannot fairly hold me to the same standards. That argument sounds sympathetic. It may even sound logical. But in court, sympathy and legal authority are not the same thing, because the real rule is not, you are pro se, so the rules do not apply. The real rule is closer to this. The court may read your filing fairly, but you still have to play on the same field, and that difference can decide whether a motion is heard, denied, dismissed, stricken, or ignored. So, we are looking at the phrase not learned in the law, what it means, what it does not mean, and why pro se litigants often misunderstand the one protection they actually do have, because liberal construction is real, but procedural immunity is not.
Not learned in the law is descriptive, not magical. The phrase does not mean, I cannot be held to deadlines. I do not have to cite authority. I do not have to follow service rules. I do not have to present evidence. The court must explain my case to me. Or, my confusion becomes a legal defense. It means, this person is not trained or qualified in law. That matters for how a court may read a document. It does not usually change the rules governing the document. The pro se protection that actually exists is liberal construction. A court may look at a pro se filing and say, this person did not use lawyerly language, but we can understand the basic claim or argument. That is different from saying, this person did not follow the rules, so we will pretend the rules do not exist. Liberal construction helps the court understand what you are trying to say. It does not supply what you failed to prove. Haynes v. Kerner is commonly cited for the principle that pro se pleadings are held to less stringent standards than formal pleadings, drafted by lawyers. But courts are not your lawyer. A judge may give a pro se filing a fair reading, but the judge generally cannot rewrite the motion for the litigant, create arguments the litigant did not make, gather evidence for the litigant, fix bad service, extend missed deadlines without lawful basis, ignore jurisdictional requirements, or become an advocate for one side. The judge may be patient, but the judge may not become your paralegal. The hard rule is that procedure still matters. In McNeil v. United States, the Supreme Court rejected the idea that ordinary procedural rules should be interpreted to excuse mistakes by self-represented litigants. If a rule says you must file by a certain deadline, serve a party a certain way, exhaust a required process, include a required certification, or support a motion with evidence, the court generally does not erase that rule because the person is pro se. In McWethy v. McWethy, the court used the phrase not learned in the law and said rules cannot be applied differently merely because that party is acting pro se. That is the opposite of what many people want the phrase to mean. A poor argument would be, I am not learned in the law, so I cannot be held to the same standards as an attorney. This fails because it asks the court to create one standard for lawyers and another standard for non-lawyers. A better argument might be, I am self-represented and not trained in law. I respectfully ask the court to liberally construe this filing. I understand that I remain bound by applicable procedural rules, deadlines, court orders, and evidentiary requirements. This works better because it asks for fair reading, not special treatment. If a pro se litigant files a complaint with awkward language, but the basic claim can be understood, then the court may read it generously. If a pro se litigant misses a filing deadline and says, I am not learned in the law, the court is likely to state that usually does not solve the deadline problem. If a pro se litigant files a motion full of accusations but no evidence, the court may understand what the person is alleging, but allegations still are not proof. If a pro se litigant files documents but does not properly serve the other side, then the court may refuse to act until service is corrected. Representing yourself does not make you a lawyer, but it also does not remove you from the rules that govern the courtroom. That is the uncomfortable balance. The court may understand that you are not learned in the law. The court may read your filing with some patience. The court may try to identify the real issue behind imperfect wording. But the court is not required to rescue a defective case from missing procedure, missing evidence, missed deadlines, or unsupported claims. So if you are pro se, the better approach is not to demand exemption. The better approach is to show respect for the rules, ask for fair construction, and make your filings as clear, supported, and procedurally correct as you can. The phrase "not learned in the law" is not a courtroom escape hatch. It is a reminder. You may not be trained in the law, but once you step into court, the rules still matter.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.